Hi, everyone, and welcome to the Wall Street Blockchain Alliance Crypto Roundup for September 22nd, 2023. I'm Josh Klayman, and our normal co-hosts, Ron Quaranta and David Brill, unfortunately cannot be here today. They send their apologies, but we are thrilled to have with us an amazing guest co-host, Andrea Tinianow, who, in addition to being an amazing lawyer and a great friend, has been with the WSBA since the very beginning and is a member of the WSBA Advisory Board. Welcome, Andrea.
Thank you, Josh, and thank you for that very warm welcome. Appreciate it, and I'm happy to be here.
Thanks. Before we get into things, including hearing a little bit about you, just want to give our usual disclaimer. Nothing that we're about to say is accounting, investment, legal, tax advice, or really any kind of advice. It's just our thoughts, and nothing that we say is necessarily the views of anyone other than ourselves, right? Not necessarily our employers, the WSBA, or any other person or entity. All right, with that out of the way, Andrea, so I know we have a lot to cover because every week is chock full of new developments.
Absolutely.
But before we do, I know my understanding is you started out as a litigator, and since then you have done so much more. Not that being a litigator isn't enough, but I'd love if you'd be willing to share with the audience a little bit about you.
Sure. Thanks, Josh. Yeah, I started out as in litigation and then very quickly moved in-house. I was in-house for 11 years with a very big global company that is in the registered agent business and does trust work and a whole host of other services. And we met through my work when I was in the state of Delaware, and I started the Delaware Blockchain Initiative. And that brought me to you. It brought me to Ron, WSBA. And when I left the state of Delaware, I could not go back to practicing mainstream law. I stayed in the blockchain space and have been working with various organizations, blockchain companies of all stripes in the space. And I am still working actually now as a consultant. And I'm also teaching a blockchain law class in Delaware, which has been is just quite a lot of fun because there's so many exciting developments. As you know, every week there's something new.
Yeah. And those who may not remember, or you should, hopefully, Andrea is also known as the blockchain czarina of Delaware. And I'm actually quite jealous of her students to get to hear Andrea's perspectives in the class.
That's very kind of you. Thank you, Josh.
Oh, my pleasure. So speaking of your experiences, a lot has happened just in the past few days with New York DFS. And yeah. I believe it's the case. Didn't you testify on a hearing earlier this year?
Yeah, a few months ago, I gave testimony, and I was actually there in support of DFS Superintendent Adrian Harris, because you may recall the Attorney General had come up with some ideas, some regulations for the state, which was not necessarily counter to what the BitLicense was doing, but was really just additive. And so there was a hearing, I think, really for the state assembly people, for the committees to understand, what was going on. So they had testimony from both members from the Letitia James, the Attorney General's office, DFS superintendent. She testified for an hour, really about sort of what she has done to create, I think, one of the strongest and most important regulatory frameworks and departments, not just in New York, but in the world. I think the New York State Regulatory Authority, DFS, is a leader, and jurisdictions around the world look to her. She is, I know, a well-known speaker around the world, and look to what New York is doing, and often, like I said, emulate what she's doing. So at the time, the Attorney General had come out with a really prospective possible regulations that would require various entities to sort of break up their organizations into separate units. So you couldn't, for example, have a group, an exchange that was on both sides, trading on its own account. I mean, there were a whole lot of regulations, a lot of restrictions that would have, I think, torn up most of the businesses that were duly licensed in New York, and they would probably have to start again, or they would have to leave. And I don't think that the regulations that the AG had brought out have been introduced, at least as far as I know. I haven't seen that they've been introduced in the assembly. So I suspect it was really interesting because at the hearing, a lot of the assembly people in the beginning, they were very supportive of, I think, the AG, and they're like, oh, we haven't done enough. And, there were a lot of people who were injured when Genesis, when they filed for bankruptcy, because the Gemini and Genesis had an arrangement, and then Genesis failed, and a lot of New Yorkers were impacted. They still are impacted. And, they're like, you didn't protect, they were really very aggressive. And then by the end of the hearing, everybody after, everyone heard from, after DFS Harris spoke and others spoke in support and really explained what she had done, what the bit license does. I think everybody sort of was like, oh, yeah, okay, keep on doing what you're doing. So I think what we're seeing here with these revised guidance from the DFS, which we mentioned, my guess is that that's responsive. It's coming up. She's identified new issues that need to be addressed. She even said in the hearing, yes, we have a long list, and we're going to be addressing those issues. And I think that's what we're seeing here is, I think some of the new issues have to do with delisting, and we also, which made a lot of headlines, the idea that they reduced the number of tokens on their green list. These are tokens that can be exchanged without any further research or vetting. And now I think there were just two virtual currencies, Bitcoin and Ether. So, yeah.
So do you think at the time when you were testifying as part of that panel, do you think that these were in the works then? Or do you think there's been something since then that has really jump-started things?
Yeah, well, I do believe that the DFS. I mean, I think if you read the articles, they have. Did they say they have 80 people or 60 people? They have a very strong group of practitioners with excellent expertise, and I think that they've been paying attention. They have been paying attention, and they've been keeping a list. And I suspect they would have done. They were going to come out, they would revise their regulations, and they would, because of all the issues that have, we've seen, it doesn't surprise me that the state of New York and DFS, the regulator for crypto in the state, would come out. But, my guess is that there's probably influence and pressure from, the AG's office, which is just hovering, right? Waiting to pounce.
I mean, it's really interesting that in this refreshed guidance, of course, Ether is still listed as a green listed coin. When you contrast that with, the KuCoin case brought by the AG, which said, among many other things, that Ether was a security. So interesting moves.
Yeah, and also we have the waffling testimony, or not so waffling, on the part of Gary Gensler and the SEC about whether Ether is or is not a security. So I guess New York has decided that Ether, they're gonna put their stake in the ground and say that Ether is not a security, and they're green listing, and go forward.
Yeah, I mean it makes sense. It's really interesting. I think this is something you mentioned to me as well separately, which is a lot of the talk has moved away from talking about BitLicense to Vault.
Vault, yes, I suspect that's branding, like power. But I think what's really interesting is, we've seen Congress just fail in their role to enact legislation to regulate crypto. So, it may be that DFS Harris has also seen, that she has to step up again, and New York has to take the lead, and not just has to take the lead, but as the corporate finance capital of the world, this is a banner that they wave, and they want to continue to provide leadership where Congress has failed. And I think, sure, good. That's why that's why they got started all those years back when the bit license was introduced. And I think all of us were like, oh, the bit license, so many regulations. Oh my God. And now we're like, yeah, okay, we get it. Keep on going, because it's not, Congress can't even get their act together to put a budget together. I mean, that's the least they can do. So
I mean, you're absolutely right. I mean, it's really interesting when you mention the budget, right? Because Congressman Emmer had introduced a potential amendment that would ban the U.S. Not the U.S. the SEC
Ban
from
the SEC, right?
from using funds in crypto enforcement because or unless and until clear rules as was envisioned in this
Right.
potential amendment were put in place, which begs like it makes you ask, well, how will you know when clear rules are in place and
Yeah. Or
who will decide?
any rule, any rule.
Right. And if that were to be adopted and become part of the appropriations bill, what does that mean for judges who may be looking at these cases if Congress has a portion of the appropriations bill that says no clear rules exist?
Yeah, I think it's kind of a mess. I honestly, like, you've got Congress saying that the executive branch can't do their job, and I mean, I don't know. I don't even know how that is constitutional. I mean, maybe it is. I'm not a constitutional scholar, but somehow it seems, the SEC is empowered to bring enforcement actions, and then they say, well, you can't bring it of a certain nature. I mean, I don't see that having a whole lot of. I mean, it could succeed, but wow. That really would be a mess. And it would put judges in just a horrific political position where that's not what we want our judges doing. There's so many.
Sorry, go ahead.
Please.
Like, how do you even go forward from that? Like, and then decide, okay, now the rules are clear, right? When we know that the laws that are passed are likely going to need further massaging at the regulatory level.
You know what, Josh? Here's what I think. I think Senator Emmer right? Representative Emmer could pass that bill. And you know what would happen? The SEC would say, oh, the rules are clear. They've always been clear. We have very clear rules. We don't need any other rules. They all apply. They're all tokens. So I don't really see how that bill is going to help anyone.
I totally hear you. And so it is always interesting to know, like, people obviously have strong views, including in Congress, and they make them known in different ways. But as was pointed out, I believe by former Congressman Toomey, just very recently, gave his prediction that notwithstanding anything that happens to the congressional bills in the House, he doesn't believe that there is the will. This is a paraphrase of mine based on what I've read. He doesn't believe that there is the will to pass them in the Senate, and that I mean, it was predicted that he. I mean, he still seems to predict that a federal stablecoin bill would be the most likely to pass. But it is interesting to hear people speaking that plainly. Certainly, Toomey has been a great supporter of the crypto space.
Oh, absolutely. But I think you really just need to look at what's going on in Congress. Like I said, I mean, there's some bigger issues than this. It just seems like crypto has become, once again, there was great focus and there were hearings and people cared, and then on to the next thing. And right now, I think the next thing is concern about the budget, and will the budget get passed? And also, I think the dysfunction that we're seeing in Congress. It's just House, it's just House of Representatives. It's problematic. So yeah, that doesn't surprise me that you have someone saying, oh, I don't think the bills are going to get passed. No, I don't think so either. You don't think so either. I think most people you poll, it's unfortunately. And that's why we're seeing, I think, groups like New York State and the IRS, proposing their regulations that could have really an outsized impact on the crypto community, and with their definition of brokers and seeking to extract. Of course, we talk about extractors of taxes and rent and everything else, and they're looking to extract taxes from people who are making money on trades on decentralized protocols and centralized protocols.
Yeah, I mean, as we talked about just last week with the Stoner Cats settlement, right? One of the notable points in the settlement at the end was within a certain number of days, all of the wallet addresses had to be delivered. Query whether this is part of a larger piece to extract taxes from from people who may have, you know,
may have made money, although maybe that likely they're not going to make money in the future. But maybe, you know, there was a lot of trading in the beginning, and there were a lot of people who dumped their stoner cats and made a quick buck. So, yeah, the IRS is. I know a few months ago, a headhunter reached out to me that, do I want to get involved with the IRS? They're putting together a group, and I was like, not there, but somebody took that job because they're on fire and they're going to be, you know, looking to collect taxes.
Yeah. Yeah. And by the way, what I just mentioned about the stoner cats, so it's not based on any kind of information. That's just
Of course. No. We none of this. We're just reading the paper like everybody else, and absolutely enjoying our own conclusions. Certainly.
And didn't you mention previously, well, in a different, not here previously, but just about the potential expansion further beyond what currently exists with respect to the IRS and what they're looking to reach?
Well, I think
Things
just
that are excluded now that will be looped in.
yeah, those these proposed, I think the proposed regulations, you know, they're looking to assess. Yeah, what was really interesting is I was looking at the regulations, and they were saying, you know, I've got it out in front of me. The proposed regulations would cover any service, and the term of art is effectuates a sale of digital assets. So they're talking about trading platforms, order matching services, market making functions, and they exclude certain, you know, decentralized types of technology. But they say something that ultimately we will require operators of decentralized exchanges to collect customer information. So that's not on the table now, but they see it happening in the future. And that's consistent kind of what we're seeing in some of the other cases, like, you know, Tornado Cash, as I know you've discussed, where they found it was a person, like code is a person. And we've got Tornado Cash, and then we've got
with the DAO, and then the code was the property of the
code is property, like code is property, and Tornado Cash Decentral Protocol is a person, and then we have under the Coinbase complaint, a wallet, a digital unhosted wallet, is a broker. So, you know, I think, as for me, it's baffling. I mean, we always wondered, right? You've got decentralized systems. It's a new type of technology. We've got regulations that have, in the past, they regulated intermediaries, people. We said, how are they going to do this with code? How is that going to happen? Oh, now we see code is people. Code is.
Yeah. I mean, by the way, just thinking, since you mentioned the Tornado Cash case and previously the Uniswap case, right, where that case was dismissed.
Yeah, the judge dismissed the case, a decentralized protocol. She decided, I'm not gonna weigh in here. This is Congress's job.
So what's really interesting there to me, among other things, is this idea. Well, in Tornado Cash, you know, they struggled. They found a person. They found property, right? And then in this other case, there was sort of, you know, how could we hold liable these people who put in place this code just because someone else used it for something? Do you think the national security angle that appeared in Tornado Cash with North Korea, do you think that may have made a difference in the result there?
Yeah, I absolutely do. I think with the Loon v. Department of Treasury, the Tornado Cash case, private cause of action. I think that absolutely the judge wanted to support the Department of Treasury. There's a lot at risk here. You know, it's the security of the country, and they needed the regulations to fit, and they made it fit, and it's uncomfortable. But with Uniswap, it's a bunch of people who lost money on scams. People lost money on scams. Okay. They didn't allege that North Korea was, I mean, if they had alleged and had evidence that North Korea was the one making the money, then maybe we would have seen a different, you know, outcome. But they just said, you know, people use this platform to create scams, and I was injured. And the court was like, yeah, but the platform isn't the one that did the bad acts. They enabled the bad acts. They didn't do the bad acts. And you can't, you know, you don't have a defendant to go after. There's no one for you to sue. And frankly, I don't want to go out of my way to help you. I mean, honestly, the court could have, but it didn't. It didn't, and they could have thrown the plaintiffs a bone, but they said no. I'm not getting involved here. And I think the court really was like, this is infrastructure, and just like we don't hold the roads responsible for the getaway cars that steal the money, and we don't hold the letter carriers responsible for the letter bombs or the scammy letters that get sent out. Like, we will not hold Uniswap responsible. End of story. End of story.
So interesting that that judge is the same judge as in the Coinbase case, the SEC v. Coinbase case, because many of the similar arguments are being made in that case. And to go back to Congress for a second, one of the briefs that was one of the amicus briefs that was prepared on behalf of Senator Lummis by, I believe, Klayman Siddiqui and his colleagues.
Yes, an excellent brief.
That it basically, among other things, says, yes, this is a matter for Congress. And in fact, Congress is addressing it right now. So it's even if we take what, say, Toomey has said, in his speech about, the likelihood that things go forward, I actually think just having things being discussed, not only does it move forward the thinking, and components of various proposed legislations could be used in different ways in the future, but it really, it really is in real time having effects on the cases.
Absolutely. Well, what's happening, we talked about policy by enforcement. Okay, that was one thing. Oh, policy. And now it's not even policy by enforcement. It's like you've got private litigants, because we are a litigious nation, but this is what happens, when Congress does not. It really creates fertile ground for lots and lots of litigation and for disparate results. And that's what we're seeing. Uniswap on the one hand, right? And Tornado Cash and Loon v. Department of Treasury on the other. Like, this is not a consistent way, I don't think. Clearly different ideas, but there's not a consistent path forward. And it would be much better if we could have some, more formal standard rules. But what I'm hoping, Josh, just like I'm hoping when it comes to the budget, maybe you could have some moderate Republicans and Democrats work together to pass the budget, work together. Stable coin, which is what, Toomey was saying, like, that's one. Yes, that's a no-brainer. Really, the stable coins are being passed in every part of the world. They basically all say the same thing. There's best practices. Like, just do it. Like, don't politicize it. Just do it. Protect your people. Get together, guys. Republicans, Democrats, get together, make it happen.
You're absolutely right. It's interesting too, as we think about the various paths that people are taking to have to try and get things passed, to do things lawfully. Not only do we have people applying to the SEC for different sorts of approvals, right, and Congress trying to get things passed, and people testifying. It was just in CoinDesk today. I don't know much more than the headline, but that there was a prediction market that was looking for CFTC approval to have a prediction market on which party would control Congress.
Right, which one would, and the CFTC said, nah, we don't want that one. We think that's against public policy, right? That was sort of
right. And also, I think there was like the gaming law component too.
Oh, yeah. Well, yeah.
Yeah, so not taking a view on whether this was good or bad or what, but it is an interesting situation where in various markets, people wouldn't even ask for permission, right? They might just launch ahead. And I think the very fact that people are seeking out regulatory approval, I think it shows, number one, the maturation of the market, but also that people really are trying to comply, and so I do think for regulators and others, understanding that people are trying to find ways to be compliant is really important, because it's not just people trying to do anything they want. Hopefully we'll see more things that are approved, right? And again, not taking a view as to whether that should have been approved or not, right? Certainly that's beyond the scope of anything I've read. But just thinking about, like, as we see headlines like that, people are trying. People are really in good faith making applications.
Yeah, I think what's interesting is, yes, people are trying, and then we're seeing these interpretations of the law, which, I think reasonable people would really disagree about that. Like I said, the code being people. I think we're seeing this and we're going, wow, does this make sense? Is this the way to go? Maybe we should have new laws, maybe, but we can't, but because we can't create the new laws that we need, we basically, I think, tie ourselves in knots to come up with interpretations that I think are just rather unusual. Let's just say.
Yeah, and this straining to find a particular result, I would say, well, this is probably beyond the scope of anything we discuss normally on this call or on this podcast, right? This live podcast. With the Kirshner case, right, about term loans and basically with the entrance of hedge funds into that space and trying to figure out whether these loans are in fact securities or not. Certainly, and that's been a big case in a different, not necessarily the digital asset space, but otherwise, the court applied Reeves, which we see applied in digital assets.
Oh, yeah, of course. Yeah,
right?
Yeah.
And then you can see the court, in my view, straining to find that these loans, in the hedge fund context, that they are in fact more like bank loans, right? And that they are not securities. But you see, as they go through the prongs, well, this part looks like an investment, but the prescription.
Yeah, no, absolutely. But that's what happens. I mean, the law stretches. You have new technology, and the law stretches and stretches, and then it doesn't look like. And then and then maybe there's a new law that's passed, or I will tell you, in this law class that I've been teaching, we looked at all the cases that have to do with whether or not crypto is property. And we looked at a bunch of cases from England and Singapore. In the US, what's really interesting, as we all know, I think it was 2015 or 16, the IRS went, crypto's property. But in these other countries, they struggled because they had hundreds of years of thousands of years, right, of jurisprudence about what is property. Property is something you possess, or property. I mean, property is a right you have that you can take to court. And all of a sudden, they had plaintiffs who had suffered real damages, and they're trying to get relief under the laws of these countries, but they only get the relief if it's property. Only if it's property. And the courts are like, oh my God. And so what they would try to do is they would, in some of these cases, they would just narrow the relief to well, just in this case, because it's just a preliminary injunction, or just in this case because of this. And none of the courts really wanted to say, yes, it's property. And then there was one case which went on about the hundreds of years. And then they were like, it's property. Boom, they just did it. They're like, I'm just going to jump the Shark Tank. Yeah, I know it's not, you don't possess it, but it's got value. And it's like a river that doesn't know where it's flown. It's we don't, it's still a river. We don't know it, It was an amazing case, and it was amazing analysis. But yeah, at the end, they had to get to the result. They had to get the result. They had to find that the person should be entitled to relief. And I think that's what we're finding here. Department of Treasury, Lewin v. Department of Treasury, Lewin, in the tornado case, they had to find that OFAC could add that tornado. They had to do it for the security. That's what so they stretched and they contorted and they did what they did. So I think we're just going to see more and more of that.
Yeah. I mean, what's really interesting too is okay, so for each case, if it was straining to get there, will the technologists, will the developers develop something else that's outside of it? Because of course this is evolving. And once we have, AI, which already is writing code, I often think and I probably have mentioned to you in a different context, what if the ICO boom had been written by AI, right?
Right.
What if the white papers and the code? What if the people were that much further removed? And I do think.
It's true, but you know what? And this is what we're seeing from the CFTC, and this is what we're seeing from all the regulators. They're saying there's always someone. And I think it was in that report, the IASCO, their recent report. If you look at that, they're like, DeFi, yes, it's DeFi, but you know what? There's always someone, and we can find that someone, and we will hold that someone responsible. And the two founders of Tornado Cash, they've been indicted, they've been charged. I don't know anything about them. I don't know what they've done, presumed innocent, but all right. That's why you have certain people who are coding and they don't want them to, they're totally off the grid, right? You don't want to know who they are, and they don't want you to know who they are. But that's what they're saying. I mean, that's what global organizations are saying. That's what the regulators are saying. Okay, you can be decentralized, but at some point we're going to find somebody, and we're going to hold them responsible, and you're all going to be, liable.
Yeah. Yeah. I mean, and we've seen that like with Ether Delta, right? And Zachary Coburn, right?
Oh, yes.
Finding
Yes.
someone, or even with the Dow report and finding that Slockit, the promoter,
Was
wasn't
more involved. Was
Yeah.
more involved than we thought.
Yeah.
Absolutely. It all started with Slockit, didn't it?
Yeah. I mean, I think there's so much going on. I mean, one of the things with the DeFi cases that the CFTC recently has brought, just wondering, do you have any thoughts about that, about them? I mean, it's really interesting that just as with the SEC, we've seen Commissioners Peirce and Ueda like have dissents. We have, I believe it was Commissioner Mersinger, right, who had a dissent about the CFTC cases, essentially saying like, have we really shown that there's harm? Like, who's being harmed here?
Well, I think the idea is just that you don't get to avoid, protocols. It's part of that, really sort of part of the whole global policy, that same function, same legislation, same regulations, same, and that's what that's why they went after UkiDAO, and which is the case they just settled like 3 cases, right? With that's what this is about. But they're starting with the small ones, right? They didn't go after Uniswap yet, right? They didn't go after the biggies. I don't think, right? I don't think, it was just 3 smaller ones.
Yeah. And I think, by the way, since we're on that, I know we're getting a little short on time, but you've really I've heard you speak about that Northern California case.
Oh, yes,
predecessor DAO to UkiDAO. And I think the takeaways from that, I always love hearing you explain them, because really, if we look at it, it's like mapping ways to hold someone liable. And so, UkiDAO was one approach where the CFTC said that the holders of governance tokens who exercise governance,
right,
and then the predecessor, BZX DAO, right, that was treated differently. Would you be able to just explain that?
No, here's my take, and I would just have to remember the case. But in Sarkoony v. and I can't remember which DAO. I think it was UkiDAO. But basically, in that case, it's here's the thing. Yes, it's a class action. The plaintiffs, in that case, you had a coder who, if I remember correctly, the coder failed. I'm sorry, I don't want to conflate the cases.
No worries.
No, that was the case. That was
about the duty of care and negligence.
I'm sorry, what?
It was the one about duty of care and negligence.
Yeah, so basically you have a coder. There was a phishing attack. You have plaintiffs. They lost their crypto on that platform, and so they brought a lawsuit. They alleged that anyone who held a governance token was responsible for the DAO, and the court basically agreed with them, and they found that the coder had breached its duty, that under California law that there was a special duty of care, and it was breached, and as a result of the breach, the coder and the token holders and the founders, they were all joint and severally liable for the breach. And so that's kind of interesting, because under California law, they found that there was a duty that the coder owed to the shareholders, whereas there's another case in England called, it's a tulip trading case that involving Craig Wright. And in that case, you have an appellate court that found that maybe coders could have fiduciary duties to token holders. They let the case go through. That was on appeal. So you have this trend having to do with holding coders responsible. And what's really interesting is you could contrast that to a case out of New York called, oh God, there was a case there. Now I'm going to forget the name. But in that case, basically, you had something similar, and it basically almost all the claims got dismissed, except for claims involving the Electronic Transfer Act, electronic EFTA. I'm going to forget that too. Anyway, so yeah, what's really interesting about that California case is this notion that the coder, that they found that there was a special duty under California law, but not under New York law.
And what's so interesting too, I think, is for those who are listening who may not be aware, joint and several liability, finding joint and several liability, that's a big deal, right? And this goes to the idea of whether with a DAO, if some people say, oh, under certain circumstances, if you haven't used the right setup or other sorts of things from a corporate or organizational perspective, you could be in a general partnership. So joint and several liability, that doesn't mean Andrea and I are in cahoots and we divide up equally who owes what. It could be that if you're the deep pocket or if other people are somehow unreachable, you're responsible for it all because you're joint and severally liable.
So that case in New York is called Rider, RIDERV, Uphold HQ. So Uphold HQ was the exchange that had been hacked, and actually had been hacked a couple of times. So it was like the third time or the fourth time was being hacked, and the court was like, you were on notice and you should have known better. And anyway, but a lot of the claims got dismissed except for that electronic EFTA.
And that concept of foreseeability, I feel like that came up in the Northern California case too, right? That it was not just that there was a duty that was breached, but it was foreseeable that this happened. And then it was, if I remember correctly, didn't the court say something like it was, they used very strong language about saying like that it was, I forget the language, but it was something saying like you really should have known.
But that was, but I think the court was outraged, and the court wanted to, that's sort of how the courts often go. Like they want to find the relief, and then they backpedal, and they found, like, obviously they found that there was a duty.
So I just want to acknowledge, thank you, Greg Murphy, our friend and WSBA member, for your vote of support. We're glad you're enjoying it. It's great to hear from you. I guess, Andrea, are there any other topics that we haven't covered that you want to touch upon? Or if not, is there something in the next week that you're really looking forward to or excited about?
Monday is Yom Kippur. So I'm not excited about it, but I never know what's going to happen next. And, you could go for a bicycle ride and come back and find out that an opinion has been issued and it's changed everything. I think on my calendar, something's happening on October 3rd in the Coinbase case, which that's not next week though. Yeah. SEC replies to Coinbase motion. That's on October 3rd, but that's not next week. No, I don't know. We just, we keep on, every day is a new day, and something exciting to read, something exciting to watch. That's why we're in this industry, and keep on moving forward.
Absolutely. Very well said. I hope you'll come back and join us.
Thank you,
for another episode. And this has been a real treat. And when you say, oh, I forgot for a moment, the amount that you have forgotten for a moment is more than many, if not all of us, have remembered.
A lot of fun. And thank you and Ron and WSBA. I'm so happy, and really I am so honored and just lucky to be a part of your community. So thank you.
Well, we're all lucky too. And I mean, you're on the board of advisors, so it's, we're benefiting from your advice. But thank you, everybody. I hope everybody has a great week. And again, Andrea, thanks for joining us. And we'll be back with David and Ron next time.
Take care. Bye-bye.
Bye.